Portal Williams.
Tēnā koe, Mr Speaker. Tēnā koe te whare. Thank you for the opportunity to rise and take a call on this bill. Firstly, I just want to raise the matter that the previous speaker has touched on, in that when does owing something to somebody become a technical matter? In the case of, as my colleague pointed out, in the case of an individual owing the government, it is not technical, but in the other way round, when the government owes the individual, it becomes a technical matter. Mr Speaker, we're pleased that the government saw sense to take this portion of the Social Security Extension of Young Persons Services and Remedial Matters Amendment Bill out of that particular bill and craft a piece of legislation on its own, because it is an important aspect and it is a standalone, one-off situation that needs to be dealt with separately. There were concerns when this was discovered within the aforementioned bill that it would become a matter that wouldn't receive the full attention that it requires. What we are concerned about are the rights of those who are seeking to make a claim, and that their arrears, their rights to seeking those arrears, have been curtailed for those people who may have been able to make a claim for arrears that occurred between 1998 and the period halfway through 2014, when this original technical matter was found by the ministry. And that's an important issue, because it hasn't really fully been explained or justified why the ministry has decided on this period. I know that the technical matter was discovered at one point and the ability to fix it happened at another point, but that doesn't excuse the ministry or the government from looking at what was actually owed to those people from 1998 and having a conversation with them. We've had no information provided about what the cost of that might be. How many days are we actually talking about? There is no information to give us a real sense of what is going on here and how many people might be impacted by this. And in that case, I find this really unfair. There will have been people who may only be entitled to claim one day, but there are people who have, for example, seasonal work that may be on and off benefits, on and off stand-down periods over a course of many years, who will be owed quite significant amounts of money. So in terms of that aspect of natural justice, those people will not get an opportunity to make a claim whatsoever. And that is technically unfair. So when we're also looking at, so here we are in urgency again, and a truncated process without the ability to get really, really sound information, particularly from submitters, people who may have a slightly different perspective and should be given full consideration of those views. And yet again, we are not able to take full opportunity of what those views might be. So there'll be no select committee full examination, but we do want to look at what people are already saying out there in the public about what's going on. And I just want to quote from something that was in the Waikato Times, that illustrious publication, that the Ministry of Social Development takes a dim view of benefit fraud. We all know this. It has about 100 specialists who investigate abuses of benefit system or accusations that some welfare recipients have pocketed money that they're not entitled to. However, so the overpayment of benefits is one reason why money might be owed, and this can arise where changed personal circumstances affect a beneficiary's entitlement. Underpayments are another matter. The government can simply write a new law to validate the shortchanging of beneficiaries, as it is now doing to deal with the costly implications of serious maladministration. Yes, this is a matter that has been discovered in recent years, but it is not an issue that relates to just that time period with which that matter came to light. It is an opportunity to review more fully, the implications for those people who may have been affected earlier on. And just in relation to the Department disclosure statement, because there is no regulatory impact statement, but there is a Department disclosure statement. And I just want to look at a couple of aspects of that statement, 4.3 and 4.9, about retrospective effect. And the provisions in this bill have retrospective effect, which could be seen as contentious, as generally legislation should operate prospectively, not retrospectively. The amendment to Section 80BA to correct the commencement date of a benefit so that the benefit commences on the day after a stand-down period ends will be retrospective to 30 June 1998 in order to validate the Ministry of Social Development previous practice. However, in 4.9 we note that to acknowledge that the Ministry of Social Development's operational practice should have been amended when the error was discovered in 20 May 2014, clients whose benefits commenced after 20 May 2014 may apply for a review of the decision. Now that is the statement which I find is of most contention. The date at which the error was discovered is the date at which claims can be made from, and that is blatantly unfair. Members of the beneficiary advocacy community, such as Kay Brereton, when the error was first discovered, was very hopeful that the government would look at the legislation being retrospective to 1998. Sadly, her and other beneficiary advocates are now saddened to hear that the period has been brought forward to that date of 20th May 2014. We are not likely to support this bill unless my colleague Carmel Sepuloni's SOP and amendment are supported by the government to actually allow a period of time of 6 weeks in order for those affected beneficiaries to make the appropriate claim that they should do. And this is right, and we should allow that period for that to happen. And I don't see any reason why the government would delay that. It's certainly not giving, thank you Mr Speaker, it's not giving us any indication that there is an issue with not wanting to pay what is owed to beneficiaries for that period of time, yet we are not getting the indication that they would support that amendment. And it is a fair amendment and it should go ahead. Thank you, Mr Speaker. I will have the chance to speak more fully on this during the passage through the House, and I thank you for the House's time.
Todd Miller.